Good morning once again. It is Andre Smith, Professor Bonton, Smitty Bonton. Go by all types of names. You can call me what you like, just about. Anyway, welcome back to episode 4 of the Afrolantican Legal Academy's presentation of Afrolantican Jurisprudence. Episode 4, we're talking today about the teachings of PtahHotep. The teachings of PtahHotep and the beginnings of what is called administrative law. On top of being a tax professor, I also was an administrative law professor. Basically, how government works, how we cabin or control the discretion of the bureaucracy. I want to talk about that a little more generally. This is going to be both historical and legal. We'll try not to have it run too long, but in order for me to really get you to understand how deep the teachings of PtahHotep are, I think I need to also give you a little bit of primer on American administrative law, which to your benefit gives you some knowledge of both, right? Ancient Egypt history and present American legal history, and meld them together and do what you will with them. Again, happy Black History Month. Again, we try to do this every day, but as I've seen so far, every other day or just when we're going to try to get them out. We'll try to do them daily, but again, I know that's a little ambitious, especially when I get excited about what I'm going to talk about, because as I was trying to prepare for yesterday, the teachings of PtahHotep, there's just so much stuff, and I get so enthralled in it and so immersed in it, and just want to tell you so much that the preparation just requires a little more. As a matter of fact, I had to cut off a lot of things because there's so much to talk about when it comes to the teachings of PtahHotep. And know that the teachings of PtahHotep are also coupled with the teachings of Hegemony, right? This is a second person, a second vizier of Egypt, or Kemet, prime minister or chief justice. The vizier wore several hats back in the day. Okay, so let me just remind everyone, please subscribe to the YouTube channel, Afrolantica.com. I'm also the director of the Economic Justice Law Review. Let's also, if you don't mind, go to Amazon Kindle and purchase the book Taxes, Death, and Trouble, How Starve the Beast Tax Cuts Created the Black Lives Matter Movement, right? That's my most recent book, Taxes, Death, and Trouble, How Starve the Beast Tax Cuts Created the Black Lives Matter Movement. It's never been any more relevant than it is today, especially now with the these new tax proposals that are coming out by presidential candidates, which I do support. If we're not talking about taxes in this day and time, we're really not talking about anything. And I'll explain that in maybe some other videos. Maybe in other videos we'll talk about more issues of the day. But right now we're steeped and immersed in Afrocentric legal history. All right. So we already talked about a review of how we're going to go through 6,000 years of pre-colonial African history. We our second episode was on the pre-colonial states of Africa, well over 20 states prior to the 16th century AD, well in advance of other civilizations, and how there's a certain political unity and governance, unity when it comes to governance structure, particularly taxation, and also some cultural institutions like matrilineality and others. So today we're going to talk about the teachings. And then the third episode we talked about Mott and the origins of law, right? The idea that law emanates from agriculture originally, and that basically Kemet, as an agricultural society to begin with, deals with law, how we dealt with matriarchy, and we'll deal a little bit more with that. How Imhotep becomes one of the viziers and architects. And so this, to me, is an extension. We could have called this the Origins of Law Part 2, but I just want to take a different focus. Instead of talking about the origins, we're going to talk a little more about due process and administrative law specifically. Right, administrative law specifically, the law of basically the executive branch. You hear in law schools, we talk generally about Congress and legislature, so you hear a lot about them, and you elect those leaders, so you hear a lot about those people at election time. You also hear a lot about judges, And the judges are also the focus of law school and cases. Whenever studying case law and reciting Roe v. Wade or Brown versus Board of Education, we're talking about the judiciary, this second branch of government. But the executive branch below the mayor, below the governor, below the president, has its own structure and regulations that they have to operate under, and otherwise each person becomes their own government unto themselves. They become a king to the extent over their own fiefdom, and we don't like that, right? We don't want people to make decisions based on their personal whim. We want them to make it based on, quote unquote, the law. And we see that ancient Egypt, as far back, again, we're dealing with the Old Kingdom. We're staying in the Old Kingdom because we know that the Old Kingdom is most immediately attached to the African interior, that its cultural practices are closest, most attached to the African interior, and its Kemet's relationship with Nubia is strongest there. And we know that Nubia, we'll talk about that later in a few thousand years when we talk about the Kush, Kerma, Meroe, that becomes more or less the jumping off point for the rest of, quote unquote, Black Africa or Sub-Saharan Africa. So all that we're talking about Egypt, and although we defend Egypt's Africanness, especially when it comes to the Old Kingdom, especially when it comes to the Middle Kingdom, even parts of the New Kingdom, especially when it comes to Upper Egypt, which is the southern part. Again, I can't emphasize enough that when we talk about African cultural unity, we're talking about a jumping off point even further south down in Nubia, and the relationship between Kemet and Nubia is something that we're going to talk about in much further detail later. But right now, we're going to talk about PtahHotep. We talked about Imhotep before. We're going to talk about PtahHotep today. P-T-A-H-H-O-T-E-P. PtahHotep. Okay. Hotep was, again, it was a name that was often adopted by lots of people. And so we're talking about a second vizier. Imhotep was a vizier of the third dynasty. I believe PtahHotep was a vizier of the fifth dynasty. And Old Kingdom Egypt, again, the first through the sixth dynasties, with the pyramids, the Sphinx, and all being created and constructed entirely, gleaming in precious metals, seen from miles and miles away, solar calendar, geometry, all these other things. These are Old Kingdom creations, even by the third century. I'm sorry, the third dynasty. So the teachings of PtahHotep, the vizier, the prime minister, could be the chief justice, right? The roles change here over the course of 3,000 years. We know that the vizier starts off being a member of the royal family in the first dynasties, but then as the state becomes more sophisticated, becomes part of the larger ethnic group and becomes appointed in a more meritocratic fashion. The interesting thing about the teachings of PtahHotep is it seems here that we're still either dealing with family, right? When we're talking about how old the book is, it is recognized as the oldest book in the world, widely recognized as the oldest book in the world, at least 1,000 years older than Hammurabi's Code and whatnot. And it does reference to law. That goes back to the discussion we were talking about before. But when we talk about, but let me make this point. PtahHotep and the name Hotep, after we examine this book, I hope you will understand how disappointed and discouraged I often feel when we look around social media and the word Hotep is now used as a derisive term, that a Hotep apparently is someone who advocates for Black people too strongly. I can't tell you how disappointed I am that that's a thing, right? Someone said to me the other day that isn't it a shame that the word nigger is a term of endearment and Hotep is a term of derision. You really can't get more backwards than that. And again, if we're talking about white supremacy as a mental condition, I think there we have a strident example of some pretty learned folks who really don't care to emancipate themselves from mental slavery when they use the word hotep in a derisive fashion. So hopefully this episode will refurbish the reputation of hotep, right? Typically now we use it to regard peace. In this context, PtahHotep is an administrator. Going back to the first dynasties and the idea of a familial relationship. The teachings of PtahHotep start off as father to son, right? And so it's from the vizier to his son, and it is male. We're going to talk about how much women were respected in ancient Egypt. However, if we read the teachings of PtahHotep, we can see that there is a male hegemony arising, and we see that even the discussion, and I'm not an Egyptologist, so perhaps if I were to be able to read the hieroglyphics myself, I would dispute this, but as it's written in a very paternalistic fashion, father to son. There is mentions of daughters, there are mentions of wives, but the conversation seems to be towards the husband as in treating the wife, right? So again, if this is accurate, if it's accurately translated, that even though we do praise the existence of women as legal persons in ancient Egypt, all the way back to the Old Kingdom and on almost all the way throughout, we do recognize that it does not mean that men were not did not seize charge, and that we did not have any signs of patriarchy or paternalism, because there were. But as far as modernity is concerned, going back to how extraordinary the teachings of PtahHotep are, let me start by again praising the Old Kingdom and even using later the teachings of PtahHotep to describe and illustrate how modern ancient Egypt was. Now, I'm not going to say ancient in the modern sense. Of course, there was not electricity. The difference between a world with electricity and a world without electricity is stark. However, electricity was only corralled and mastered less than 200 or 300 years ago. So it's very interesting to see Egypt described in a way that we could describe many other places 1415 and 1600 AD and not see that much of a difference, and also for the commitment to equal protection being greater 6,000 years ago. And even again in Egyptian history, Aristide Theodorides insists that ancient Egypt never got back to the level of sophistication legally that it attained in its first 6 dynasties in the Old Kingdom. And even furthermore than that, James Wilson insists that the legal structures that appeared in the first 6 dynasties are older than the Egyptian dynasties themselves, and therefore probably came from down south. So let's talk about this more specifically. First of all, a book, pen and ink. Right? Writing. One of the things that separates ancient Egypt or Kemet from all that stood before it is writing itself. Right? And again, this is not necessarily to say it's a particular genius, although it is, but also it's a circumstance of environment. As Egypt captures or conquers the northern lower Egypt, which is the northern part up to the Mediterranean, that's where we find papyrus. Right? And so to the extent papyrus is something that helps facilitate writing, and also because of the drying nature of the area, being able to preserve writing, that's where it seems natural that it would develop, and where other places that are more humid, other places that don't have papyrus or other types of things to write on, are committed to it less. Although we see writing in the form of art and rock painting and other ways all over the continent. But writing itself, pen and paper, first dynasty of Egypt, right? 3 to 4,000 BC, right? So 6,000 years prior to us. Know that, again, law was ubiquitous. The law courts were busy, the legal officials were numerous, and so on top of the teachings of PtahHotep being a letter from father to son, its ubiquity within Egyptian circles, the fact that it's been copied over and over again, the fact that it lasted from the Old Kingdom to the Middle Kingdom to even the New Kingdom and represented more or less good conduct, a good regulatory conduct in family, social, professional, and government relations, speaks very well of it, but also speaks of how ordered the society was and how many legal courts there were to resolve disputes instead of just basically fighting it out, duking it out, or just might makes right. That the teachings of Hotep are almost absolutely against that notion. The notion that I have more power than you and therefore things go my way. Almost everything in the teachings of PtahHotep relate to an order that is attached to justice, and we know justice, balance, truth, harmony are represented by the female goddess Mat. And as they say, instruct him then in the words of old time, may he be a wonder unto the children of princes, that they may enter and hearken with him, make straight all their hearts and discourse with him without causing weariness, right? This is a prayer from the father vizier to the son, who hopefully takes over his place in the first several dynasties. Again, as we move on to future dynasties, the vizier is not a hereditary position. It becomes more meritocratic. And even in the teachings of PtahHotep, it would seem that it's not clear that the son will take over as the vizier for his father. There is a lot of uncertainty and a long path between there and the final position, and that's made clear throughout the text about preparing the son for lots of different occupations, and so the book becomes more ubiquitous. It becomes basically the first legal text. It becomes the first law book available to the many scribes and judges that that populated Egypt and helped keep that society orderly. I want to read to you what I feel is the most impressive passage. We'll get back to it, but to me it's the most impressive passage because, again, as an administrative law here, professor, the concept of due process is astounding, and especially because 6,000 years later in 2019, we still have trouble with due process. We still have a lot of trouble giving people, and especially, again, black folks without wealth, poor black people, the process that they deserve when it comes to not just crime and whether I'm guilty or not guilty of that crime, but also, again, administrative law practice. In other words, the government may have certain benefits, or the government may make certain rules, or the government may make some certain things illegal, but less than a crime, right? A violation, a fine, a fee, a forfeiture, right? And the concept of having a hearing, first of all, just the hearing itself, the fact that I have some recourse or appeal to your governmental decision, right, is interesting, right? Not just the rights against another person, a private right where they have violated a contract or they have violated the will that our father or mother has written down for us. Again, those courts were ubiquitous as well. But the idea that there was actually a hearing and recourse against the government, and that the government officials were held to a fairly rigorous standard, is what makes this commitment to due process and therefore equal protection very impressive. Again, equal protection relates to due process very strongly because if precedent, the point of having everybody judged orderly from the same standard, it preserves, again, the monarchy or the legislature, if that's what you're attempting to do. And we'll talk about that later. But even more than that, if we treat every person the same based on this precedent, based on this order, rather than someone's whim, we are more likely to treat everybody equally before the law. Okay, so let me read my favorite passage. This is basically paragraph 20 of the Teachings of PtahHotep. If you are to be a leader, be patient in your hearing when the petitioner speaks. Do not halt him until his belly is emptied of what he had planned to have said. The victim loves to sate his heart, even more than accomplishing what he came for. If a petition is halted, people say, but why did he break that rule? Not everything for which he petitions can come to be, but a good hearing is soothing for the heart. That is wildly, wildly, wildly impressive, right? Again, let me make that clear. Not everything for which he petitions can come to be. So again, we're not talking about crime, right? We're not talking about someone being convicted of a crime. We're not talking even about a contract or will contest between two peoples, or it doesn't seem that way. Here, not everything for which he petitions can come to be. This seems to be some type of grievance between the citizen and the government, and to facilitate that, a good hearing is soothing for the heart, even if you say no. Even if we're to say, no, you cannot have this thing. The idea that all people with a grievance against the government or a grievance against other people have the right to be heard. This is a fundamental part of what we in America call due process, right? So let's talk about American law for a second. We've talked about Egypt for a bit. We've talked about Africa. So let's talk about American law for a small bit, so we can then compare what I've been talking about with PtahHotep, with Mott. Next episode, we're going to talk about the tale of the eloquent peasant. Again, we'll get more into the equal protection, the extraordinary commitment to equal protection. But in American law, due process, the Fifth Amendment, right? The Fifth Amendment Constitution says we're not allowed to deprive you of your life, liberty, or property without the due process of law. Now, that's a grand statement, and it's been incorporated, Fifth Amendment, to the states, to the federal government, that if we're going to deprive you of your life, your liberty, or your property, we have to give you a due process of law. Okay, now that sounds grand, but let's flip it around, and you'll see that it depends on the people applying it. All things depend on the people applying it, because we can flip everything backwards. So, because that also says we can take your life, we can take your liberty, and we can take your property as a government, so long as the process of law we give you is due, right? Now, if we flip it that way, it doesn't sound as grand. And then that also requires us to think more seriously about what is the process that is due, right? Okay, so first of all, what is a process, right? A legal process. So this hearing, right? The way in which the law is made is a process, right? And the way in which decisions are made is a process. The question becomes due process. Process isn't that hard, although we can dispute about what is process, what helps something be fair. Again, when we talk about, to make this simple, a death row inmate, or I'm sorry, not an inmate, someone accused of capital murder. Okay, everybody has due process rights. I have Miranda rights, and everybody has those equally, that we have the right to be silent, we have the right to not have to testify, we have the right to confront witnesses, and have you. But we find that that's not enough when it comes to we also, some people get a lawyer appointed for them. That's process, but that's not even it. If you're in a capital murder case and you have a public defender assigned to you, how much money is the state going to give this public defender to hire to have DNA tests, to hire private investigators. $1,000, $20,000, $100,000, $1 million. That's still all process. That's still how much are we committed to making this fair, right? And it can't be necessarily unlimited. Otherwise, we never get anything done. On the other hand, it can't be nothing. Otherwise, a hearing becomes a sham. So this question of what process is due is an issue, very, very deep issue in jurisprudence all the world over, especially when we talk about dueness. Another word for due we'll just talk about is fair, right? A fair process. So it's so very interesting, it's so very fascinating that 6,000 years ago we had the first book that we know of dealt very seriously with due process, with a fair hearing. Okay, so in American law, again, due process is put into two different boxes: notice and an opportunity to be heard. But government operates in different ways, so this opportunity to be heard is different in the different contexts. So we always so every government, and know this, whether we're calling it a democracy, communism, monarchy, there's so many different modes of government. But did you know the world over, there's still always more or less three branches: the legislative branch, the executive branch, and the judicial branch. Now, it could be all one person. The legislative branch determines what the laws are. The judicial branch determines whether or not someone has broken the law, including the lawmakers, right? Did you make the laws correctly? And once made, did the people, or the persons, break them? And again, it could be the judges could make the decision themselves, or they could impanel a jury and preside over the case. But the third branch of government, the executive, right, executes the laws. The laws are on the books. I think you are guilty of something, so I arrest you. However, that's not the end of the matter. But at the same time, as an executive branch official, I do have that discretion. I do have that authority to arrest you because I think you created a crime, or I think you are ineligible for that benefit or eligible for the benefit. I make an initial determination. And is it just because I like you? Is it because you're part of my crew? Or what if you're down with the other squad? What if you're down with another political party and I deny it to you, right? On what basis? On what basis am I making my decisions? So a fair hearing not only requires the opportunity to be heard, but it also requires the decision makers to squelch their own personal whim and decide cases based on some principles outside of themselves, right? This is what we mean when we say the rule of law versus the rule of man. We don't like one person just saying, well, I am upset today, so you lose, or I like the way you look, so you win, or any type of partiality. Right, I'm partial to certain things and therefore they win. No, we prefer that society will be more meritocratic, more orderly, more just, more balanced, more harmonic if we follow precedent and due process. And yes, I specifically and intentionally issued out the words of Mott in talking about the goodness of due process. Okay, so executive branch, legislative branch, judicial branch. Now, the executive branch, again, in a so-called totalitarian society, the executive or the king or the czar or Kaiser or whatever you want to call them could have all of those functions. And in a small society, again, a cult or something like that of 20, 30 people, sure. But when you get 1,000 people, 10,000, 100,000, millions of people, then it's going to take a lot of government administrators to make things happen. And again, so the question becomes the discretion of those bureaucrats. the scope of the permissible delegated authority. If you're taking law school classes now in America, you're going to deal with a thing called the non-delegation doctrine. What is it can the king or the legislature or the judiciary delegate to others and not take responsible for? How are they constructed? Who can be a part of the judiciary, or who can be a part of the executive branch? Who can fire them? Who hires them? When it comes to the governors of each of the nomarchs, remember the trial of Set included 42 judges around Thoth, and those 42 judges represented the 42 provinces of 42 provinces of Egypt, each one having its own government, its own vizier, its own courts, right? And to have them all make decisions the same way over the same matter, or at least similarly with the same themes, so that we can all call ourselves a country. How do you do that? Well, you do that through the teachings of PtahHotep. Other administrative law issues that you deal with in American jurisprudence are access to the courts, who has access to justice. And again, there's a strong belief that all peoples in Egypt had rights to court access. But what we don't know is about issues regarding finality, preclusion, standing, the very precise issues that we deal with today. Now, again, as I'm not an Egyptologist, there may be records out there that do describe and illustrate those practices, and hopefully I'll discover them and bring them to you so you'll know what I know. And then judicial review, right? The modesty, the law did it. How do we get how do I justify my decisions? And the very interesting thing is this idea of precedent. We know, was there a requirement for each judge to write down the reasons for their decisions? That's under dispute. There's an argument that at least some hieroglyphics show Egyptian judges dealing with scrolls, right? And some suggesting that is a reference to legal precedent. More Eurocentric scholars dispute it. However, I would just say, when we look at these teachings of PtahHotep, it just seems extraordinary how much Egypt was committed to writing and then not to record those decisions, and especially when we say that the charges to the vizier and others by the king are very, very, very specific. That sounds like precedent to me. All right. Another interesting thing about administrative law and the teachings of PtahHotep are that it seems, when we talk about jurisprudence, when we talk about legal theory, when we talk about wise judging, that's what I kind of interpret jurisprudence as, wise judging. We're making a power play. We're actually giving power to these judges, number one, but more than that, who do the judges represent? The legislature or the king or what have you are more often attached to the people and the people's whim. If we like you, we elect you. If we continue to like you, we keep you there. But judges and priests, and sometimes, a lot of times, the priests were the judges, especially to the extent they were the safeguarders of the principles of Ma'at and the writers in temples and such. So if I'm trying to respect the legislature or the council of state or the pharaoh or the monarch, then I'm going to judge cases based on what's called legislative or intent, or the intent of the author of the law. There's a big thing going on in law schools about that. I've written several things on how do you do that? Do you respect the text that the author created and how it's supposed to be read, or assume that people are going to read it? Do you decide it based on what the author intended for the thing to mean? Do you concentrate on the consequences that the author intended to produce or avoid, the purposes of the law? Or do you, on the other hand, maybe imagine just you want this law to work generally? Or, on the other hand, you could put that aside and say, we don't care about the legislature or the author, whether it be the king or the legislature. We don't care about the author of the law. The law says what it says, but what we would like to do is adjudge it against a higher principle, a principle even detached from the current feelings about the legislature or the king, right? Something old, something more or less to conserve an older order, conserve an established order. That's what I always think of when I hear the word conservative. And so that by instilling the principles of Ma'at and teaching them through the teachings of PtahHotep and Geminity, we can bind, or at least the judges will attempt to bind Egypt or Kemet to its origination, bind it to its foundation, rather than have it morph and change based on the whims of who is particularly in power. That's a very interesting balance and power play between branches of government. Again, there's hardly ever co-equal branches of government, just like there's no two snowflakes that are the same. One typically has a little more than the other. In America, the big thing about quote-unquote judicial restraint is that we pretend, or we would like to believe, that the legislature is dominant, that of the three branches, that the legislature is the preeminent one, that the executive is also elected by the people, although not as regularly and not as directly as the legislature, right? See the Electoral College and things like that. And that the judiciary, while necessary, is the least democratic branch, and therefore should have the least power in a democracy. You don't have to agree with that, but that is the general belief, or at least what you're taught in American associated law schools. It does not have to be that way. So in a system such as Egypt or ancient Kemet, where perhaps the pharaoh or the priests or someone else is of a greater imprimatur, to have a greater respect, then we can use that to bind decision makers, not just to what this pharaoh wants, not just what this legislature wants, but what has been timeless, or what has been in the past, decide to be fair, truth, justice, orderly, harmonic, etc. And this gives a lot of power to the judges, right? To say that I can trump the legislature. I don't care what the legislature says. I don't care what the pharaoh says. It is subordinate to the principles of Ma'at. That gives them a lot of power. So there's always, and I'm sure through the 3,000 years of Egyptian history, there was a lot of hydraulic pressure, I guess one could say, that elevates some, the legislature at some times, the monarchy at some times, the judiciary at other times. Note that almost all of this comes the fall of preeminent antiquity, black civilizations in antiquity, is King Ergamenes in Nubia killing the priests of Ammon, who basically ordered him to abdicate himself, and therefore in that epic of great Nile Valley states of antiquity comes to an end. The places still are there, but it becomes more European, Mediterranean, West Asian in cultural practice. Okay, so the teachings of PtahHotep, in my view, are designed to empower the judiciary, to empower the legal scribes, to empower well, yes, I would say the executive branch, but what it does is it cabins their discretion. It basically says you have the power that you're given by the pharaoh to collect taxes. But in order to collect taxes, you have to determine how much they owe based on what crop yield, and there's different other factors, especially if you're going to include property and trade. And again, we don't want it to be whimsical. So in order for decisions to be made based not on a whim, the judiciary is empowered with these principles of Ma'at, these teachings of PtahHotep, to say what that person did. Maybe they were given the authority to give out grain, but not in the way they just did it. And that has to be changed or reformed, or someone has to be punished. And again, the idea that there's actually a petition for a hearing to determine whether or not, where I can argue in front of judges that my case is right, is just a very extraordinary circumstance and very inconsistent with the way in which Egypt and Africa is portrayed in most scholarship and most educational outlets as just a god amongst men. And this is a pharaoh or the African king, just a god amongst men who issues edicts by themselves that they are to be respected, or I kill you based on my whim, and that the judges, if there are any, and religions are just basically priests who believe in magic. This is just so, it couldn't be any further from the truth when it comes to the great states of Africa in antiquity, all the way through the medieval era, all the way up to colonialization. So to close this out, I already gave, I want to give you some samplings from the teachings of PtahHotep. I'm going to quote directly from this man 6,000 years ago, just so that you can get a sense of how modern and what was expected of you as a citizen of ancient Kemet 6,000 years ago. And I also want to make note that here we're not talking about utopia. You will see very much through these writings that ancient Egypt was not a utopic society, that there were lawbreakers, that there were people that did things that were inconsistent with the principles of Ma'at, that were disorderly, that disharmonious, that were imbalanced and unjust. And therefore, you have to have these writings to actually cabin and instruct people on how to social relations to create an order that is durable. Now, I say durable, but let's also imagine that these folks also saw themselves as more sophisticated than the quote-unquote uncultured peoples around them. So again, there's a commitment to equal protection, but there is still an issue or idea of merit, that some people deserve a higher position than others, right? Balance on the one hand, order on the other. So let's talk about PtahHotep when he even speaks of husband to wife. If thou wouldest be wise, provide for thine house and love thy wife that is in thine arms. Fill her stomach, clothe her back, oil is the remedy of her limbs. Gladden her heart during thy lifetime, for she is an estate profitable unto its Lord. Be not harsh, for gentleness mastereth her more than strength. Now, I think that's a beautiful passage. However, note that in the teachings of PtahHotep, we have man talking to son, and these are being addressed to a husband on how to treat a wife. So even though a wife is to be treated well, the fact that this text speaks to the husband is of note, that we don't see perfectly equal relations between male and female. Social conduct. Again, I'm only giving you a couple of the quotes from his PtahHotep's book. There's so many others, and you could really cabin them all and say, well, this is how to be gentlemanly. And there is a lot of that, but there is also much about how to be a leader in bureaucracy. So with social conduct, there's also references to law. And again, if there's an argument that Egypt didn't have law, how is it reconciled with these texts that instruct people on how to follow the law and what is the consequence if they don't? So listen to this. Be not covetous as touching shares and seizing that which is not thine own property. So we have the concept of property. We know everyone doesn't have the same, and we have laws against stealing. And note how many of these quotes that I'm going to give you predate the 10 Commandments and seem to be reflected in those commandments later. Be not covetous towards thy neighbors, for with a gentle man praise availeth more than might. right? Again, we're going to subordinate might. In order to have an orderly society, we're trying to restrain the tendencies of those with power to get what they want based just on strength or wealth. He that is covetous cometh empty from amongst his neighbors, being void of the persuasion of speech. One hath remorse for even a little covetousness when his belly cooleth. Note that number 6 deals with assault, right? Not just battery, the physical touching. Assault, cause not fear among men, for this the God punisheth likewise, right? Cause not fear among men, for this the God punisheth likewise. So likewise, I'm assuming here means that assault is just as bad as battery, and we see that coming forth today, that whether it's a crime or a private tort law, that those who create fear amongst other people are wrong, right? They are inconsistent with the principles of not, and punishment can be expected from not just the person who scares them. This is the important part. Punishment is not just expected from the person who was in fear, but from the state itself, because this also is an offense against the state. But we're also going to talk about order and the sophistication and occupations. Bend thy back unto thy chief, thine overseer in the king's palace, for thine house dependeth upon his wealth, and thy wages in their season. How foolish is one that quarreleth with his chief, for one liveth only while he is gracious. Now, it'd be interesting to me, again, as one who does not read hieroglyphics, if I could do it myself, because in certain texts you'll see chief, some say leader. And it really becomes interesting to compare and contrast the term employer, I guess you could say, with those things in the past. Master. I mean, in American law, an employer-employee relationship is still a master-servant relationship. And so someone 500 years now, looking back at our legal books, will say employees were probably slaves, just like serfs and other people. Now, again, there can be more subtle distinctions, more freedom of movement, the ability to own property. But this idea of a chief, of a boss, that other people work under them, that our wages are dependent on that, again, very modern concept. It goes further in the same passage. Plunder not the houses of tenants, neither steal the things of a friend, lest he accuse thee in thine hearing, which trusteth back the heart. If we know of it, he will do thee an injury. Plunder not the houses of tenants, not just plunder not houses, neither steal the things of a friend. So this even suggests an even higher punishment or a higher crime for those that are entrusted with certain things, right? If you are a landlord, and this seems to suggest that people were landlords, had several properties, and then were entrusted, other folks lived under their property, under their real property. And as such, you are not subordinate to me. You have to trust me, right? I have access to all this stuff. So to plunder those houses or steal from a friend seems to be especially pernicious. Number 3. Repeat not extravagant speech, neither listen thereto, for it is the utterance of a body heated by wrath. And we'll skip over a little part. And then, if thou be commanded to do a theft, bring it to pass that the command be taken off thee, for it is a thing hateful according to law. So going back to the episodes we had last episode and the episode before that about whether or not Egypt had law, that's why I don't really engage in this idea that you can't say Egypt had law unless you find the code of Hammurabi or whatnot. We have lots of references to Egyptian law from others, and especially from Greeks and whatnot, and here from Egyptians themselves. If thou be commanded to do a theft, bring it to pass that the command be taken off thee, for it is a thing hateful according to law. 22. Satisfy thine hired servants out of such things as thou hast. It is the duty of one that hath been favored for the God. 25. If thou be powerful, make thyself to be honored for knowledge and for gentleness. Right. So again, this idea of poverty, and on the one we have those in power and how to operate justly. Right. We also have amongst poor folks, right, to not steal, or those without to not steal. But those that have, again, satisfying thine hired servants out of such things as thou hast. It is the duty of one that hath been favored of the God. To those, again, it sounds very much like, to whom much is given, much is required. If thou be powerful, make thyself to be honored for knowledge and for gentleness. Right? Give, philanthropy. It talks about dealing with arguers. Right? It tells about, again, this is where we see a big commitment to harmony, right? Balance. If thou find an arguer talking, thy fellow, one that is within thy reach, keep not silence when he saith aught that is evil, so thou shalt be wiser than he. Great will be the applause on the part of the listeners, and thy name shall be good in the knowledge of princes. Right? Again, let me write that one more time. If thou find an arguer talking, thy fellow, one that is within thy reach, keep not silent when he saith that is evil. Right? So again, we're trying to, on the one hand, prevent there from being disharmony. On the other hand, we also see a respect for the law and a requirement that people basically snitch, or at least tell somebody else what they're not doing correctly. But on the other hand, if thou find an arguer talking, a poor man, that is to say, not thine equal, be not scornful toward him because he is lowly. Let him alone, then shall he confound himself. Right? So again, this concern about order, this recognition of order, that there is going to be different levels of property, different levels of stature. So again, we're not going to pretend that ancient Egypt was an entirely egalitarian, utopic society where everybody all had the same. That what we have distinctions in property, and what we're trying to do, or at least what I think they're trying to do, is make sure that those who have versus those who haven't is done through merit. Merit is a very tricky concept. It is something, again, that we aspire to. No one has achieved it, but it is something to aspire to. We see 6,000 years ago, ancient Egyptians trying to organize a society that, in my view, is based on merit. Again, these teachings of PtahHotep seem to be towards gentlemanliness. They seem to be directed towards all classes. So even if they recognize class, even if you disagree that they should recognize that certain subordinates should not have to be so deferential, even if you disagree with the substance of these teachings, I just think we can all appreciate the fact that all are addressed, that the harmony between each poor and rich, middle class, and all types of folks is a concern, and we know we can't have a society without it. And it seems to assume everyone but the king has a subordinate and a superior, right? So on the one hand, we have this commitment to hierarchy, which a lot of folks today may not appreciate or discourage or might find distasteful. But it does seem to assume that at least everybody has at least some superior, and everybody seems to have some subordinate. And towards that professional contact, there's a few other quotes. Verily, each man is created to his destiny by the God who is the chief of a tribe, trustful in following him. So we're going to bring this back when we talk about equal protection in the next couple episodes. Each man is created by the God. So this idea of all men created equal, thousands and thousands and thousands and thousands of years before it's credited to the European Enlightenment. 16. If thou be a leader, cause that the rules that thou hast enjoined be carried out, and do all the things as one that remembereth the days coming after, when speech availeth not. Be not lavish of favors, it leadeth to servility, producing slackness. So basically, this is asking for leaders to be ambitious, to be frugal. If thou be an emissary sent from one noble to another, be exact after the moment of him that sent thee. Give his message even as he hath said it. Right? There's again a precision. And the interesting thing, I brought that one out because to me that's also in private conduct, but that also relates to judging. and being a bureaucrat, that again my job is to facilitate the authority of the pharaoh or the council of state or the principles of Mott, that my personal whim is to be squelched, right? That I am not the decision maker, that the law passes through me, or at least that's what we're going to pretend, and that's what I'm going to strive to. Know well thy merchants, for when thine affairs are in evil case, thy good repute among thy friends is a channel which is filled. It is more important than the dignities of a man, and the wealth of one passeth to another. So you're basically saying your reputation is worth more than gold. Right, and not only that, it seems to suggest that in an evil case, that if you're charged with a crime or you're charged with some type of tort and you're taken to court, that your conduct, your prior conduct, is relevant, right? That as evidence, I'm lost for a word right now, but your prior conduct becomes relevant as towards whether it is to be believed or not believed that you violated the law. Okay, so we talked about familial conduct, personal conduct, professional conduct, and now back to, again, more specifically what seems to be legal and administrative conduct. I'm going to interpret a lot of times when they say if you are a leader, it seems to me that that is distinct from, again, someone who is hired or a merchant and other people discussed in these other passages. So to distinguish leader from chief, from emissary, from noble, from merchants, right? We have all these different people named in this document somewhat differently, and it shows how many things were going on at that time. Okay. All right, decorum. If thou be in the chamber of council, act always according to the steps enjoined on thee at the beginning of the day. Be not absent, or thou shalt be expelled. But be ready in entering and making report. Right? So again, coming to court, be prepared, right? With your lawyer, you could, as a lawyer, you could get kicked out of court for being unpreparedness. Do not disrespect the court's time. The council chamber acteth by strict rule, and all its plans are in accordance with method. Let me say that again. The council chamber acteth by strict rule, and all its plans are in accordance with method. You cannot find, I don't know if I can find another statement that basically says due process is important here. The council chamber acteth by strict rule, and all its plans are in accordance with method. It is the God that advanceth one to a seat therein. The like is not done for elbowers. And how about the piety of the leader, the judge or the decision maker? If thou be a leader, as one directing the conduct of the multitude, endeavor always to be gracious, that thine own conduct be without defect. Great is truth, appointing a straight path. Never hath it been overthrown since the reign of Osiris. Again, let's talk about how far this commitment to due process and equal protection goes back to even the pre-dynastic period. One that oversteppeth the laws shall be punished. At a command for the condition of the multitude, seek out for yourself every effective moment until your condition reaches faultlessness. So here we have, on the one hand, the decorum and the respect for a court proceeding that is required, but we also then have the stature and the demeanor of the decision maker himself. And then later, going back to the hearing itself. How do we treat those who are petitioning? If thou be a leader, be gracious when thou hearkenest unto the speech of a suppliant. Let him not hesitate to deliver himself of that which he hath thought to tell thee, but be desirous of removing his injury. Let him speak freely, that the thing for which he hath come to thee may be done. And last, speak thou without favoring one side, right? Impartiality. Speak thou without favoring one side. Let it not be said, his conduct is that of the nobles, favoring one side in his speech. Turn thine aim toward exact judgments. So not only do we have a commitment to due process, we also see in that a commitment to equal protection of law, where we have no distinction is to be made, not between political parties, right? We have between the poor and the rich. Let it not be said his conduct is that of the nobles, favoring one side in his speech. Turn thine aim toward exact judgments. He that obeyeth becometh one obeyed. And that is the teachings of PtahHotep to his son on how to be a good vizier or judge or chief justice of the Egyptian courts, or basically how to be an effective bureaucracy free from arbitrary and capricious decision making. An extraordinary commitment to due process, an extraordinary commitment to equal protection of law in ancient Egypt over 6,000 years ago. We're going to conclude here. Please, again, go to our YouTube channel, subscribe to Afrolantica.com, check out the Economic Justice Law Review, and also please purchase Taxes, Death, and Trouble, How Starve the Beast Tax Cuts Created the Black Lives Matter Movement. We'll be back hopefully tomorrow or the next day to talk about the tale of the eloquent peasant and continue our discussion about equal protection of the law in Nile Valley civilization. As always, better educate ourselves and our children, start and patronize black businesses, stop unduly criticizing each other, let's build, let's accumulate financial, human, social, and political capital. Hotep.